Mr. Huey and Mr. Matthews Sr., good morning. Mr. Nichols and Mr. Harvey, good morning. Mr. Ryan and Mr. Williams, good morning. Mr. Yusuf in the corner, or is he not here? Okay, all right. Okay, all right. Just want to make sure. All right. See Mr. Smith and Mr. Uhalski, Mr. Brown, Mr. Atkins, and Ms. Hilton, good morning. All right. Okay, so I think I've accounted for everybody. Where's Ms. Knight? Okay, all right. Okay, so today we'll see how much we can get through the February 21st, 2015 interview of Mr. Copeland. So at this point in time, I'll note and include as for the next court's exhibit in order, email I received from Mr. Shart with Stillwell proposed redactions. So we'll work off of that as well. I'll forward that to you, yes, ma'am. I'm gonna forward it to Ms. Weaver. All right. All right, Ms. Hilton or Mr. Shart, do you have some proposed? Okay, well, I know that the video is 3 hours long or thereabouts. So do you have some, much like we did yesterday, some time?
Yes, Your Honor, and I believe we should start with.
Do you have a transcript of that particular hearing?
We do.
May I have it? Can I use it?
You can use it.
I'll give it back. I mean, I don't want it for,
No, we'll get
for any
it.
other purpose.
Yes, Your Honor. We'll get you a copy of it.
Okay, all right.
Your Honor, I believe that it's probably best we start with the redaction that Mr. Shard has given. He wants these things redacted and those items are in dispute. And those would be the 10 timestamps that you received this morning via email from Mr. Shard.
Are there any sections that, since it's your video, basically, or you're seeking to admit the video, do you have any sections that you all have decided you're going to not play or not in contention? Have you vetted any of those with the defendants?
We have not, the defendants, and I don't know if Mr. Shard was getting ready to do that, based on what we submitted to them, we do not know if there's any parts that they agree with or not. We know that everything that Mr. Shard has sent us, we're in dispute, in dispute with us.
All right. Okay.
And so,
all right. So I'll just take by the numbers, and then we'll move on to any other persons that wish to be heard about it. So what are you marking that February 21st interview as?
This is going to be 379, excuse me, 378 Yankee Delta.
Okay.
You can, of course, indulgence, at least until we get a hard copy before you copy.
All right. Has that already been sent to all defense counsel as well?
Yes, Your Honor.
Okay. All right.
You have it queued up?
Yes.
Okay, awesome.
No, sure, you're fine, you're fine.
Was your intention to go through mine first, or?
Yeah, but I want them to at least queue it up. So why, okay, we'll take the first one. I believe that's at 3:59:50 to 4:00:20, and it apparently,
The first three, Your Honor, are all statements made by investigators. I believe they're all by Investigator Gaither.
all right, let me just kind of flesh out as well, just for purpose of record in our discussion. Number 2 is 4:08:40 to 4:09:40, and number 3 is 4:10:55 to 4:11:05.
Right,
And the first one, you've indicated that Gaither gives a speech about the need for people to step up and cooperate. Number 2, Gaither gives a speech about the work they have done. And number 3, Gaither gives a speech about doing this to protect Casey's baby girl.
right. And obviously speech is my commentary, but it's essentially the narratives given by detectives throughout the interview, which are basically giving argument and kind of parroting the state's argument throughout this case, which I think is improper and unnecessary and fails 403, because there's no probative value to Investigator Gaither pontificating about the need to protect the community and the need for witnesses to come forward, and her quest to protect Mr. Copeland's child and things of that nature. So, I mean, they speak for themselves. So, Your Honor will hear, and then I guess we can argue about it.
Okay, all right.
And Your Honor, the emails are sent to you. And Your Honor, for reference on the transcript, this will be page 13, line 19 through page 14, line 3. And we'll start a little before the conference. We'll start at 3:59:35.
I have another one. This shit, man. All this because I ain't did. I haven't done nothing. I haven't did none of these niggas, man. That's what you not understanding. It's frustrating, man. I did nothing. What you not understanding is you have it in your mind. We can't do nothing about that if you're not speaking on it. We don't know what's in your mind and what you know. And that's what's making it even more fucked up, because you holding on. And everybody else just running rampant. I'm going to jail for, I'm taking the blame for everything. I'm in jail for probation, parole, whatever you want. That's what you in jail for. If there was some other charges on you, they'd be there. And you would see it. They got me in jail for probation. Until they find out if I shot one boy.
And we ended at 4:25. We ended that play at 4:25.
Okay. All right. Why does the state believe that, that's admissible?
Yes, Your Honor. Mr. Copeland testified that Detective Gaither, during the course of any of these interviews, were forcing him to name a suspect. What she's doing here, so for context, this interview is the day after Mr. Copeland, his child, and his child's mother has been shot at. And if you can recall, in the February 20th interview, when he was with Detective Curry, which has been played before the jury, Detective Curry attempted to get Mr. Copeland to tell him who did it. He did not. If you can recall, he would not say who did it. Detective Curry went into a conversation with him saying, I know you know, I could tell by your body language that you know. Then when he was by himself with Deshawn, his girlfriend, he told his girlfriend, I know who killed me. I know, I'm not killed me. I know who shot at me. This is the next day in which they knew that he had a relationship with Gaither. If you can recall in that February 20th interview, they kept telling him, you need to talk to Gaither. You need to call Gaither. And now Gaither is trying to get him to come forward with whomever he saw in the day that he was shot at. And so what Gaither is doing during this portion is telling him, I can't stop them from shooting at you. I can't stop them from doing anything if you don't tell me what happens. And majority of this interview is her trying to encourage him to tell what he knows. And that is, again, in contradiction to what Mr. Copeland has said on the stand, that one, that they were forcing him. They were not. And you can see throughout the conversations here, they're never forcing him to do anything. Two, Mr. Copeland eventually says that I wasn't, that Tay never killed me. I think he said, I swear on my child's grave or my mom's grave that Tay never did it. And this whole entire interview is them talking to him about what has been happening, the shootings, the retaliatory shootings, and encouraging him to tell them who he knew shot at him, his child, and his child's mother. So I think this is relevant, one, to contradict Mr. Copeland's in-court testimony that they were forcing him to do anything. Two, to show how the police were attempting to get him to give information, which was in a calm fashion, which was in a fashion to get him comfortable enough to be ready and prepared to make an identification. And so we believe it's relevant to show the jury they weren't forcing him to do anything.
Mr. Short?
Well, I think if you look at that exchange in isolation, it is a narrative by the detective. It's not prior inconsistent statements by Mr. Copeland, but you might say it's not that egregious or, what's the big deal? I think as we go on and we discuss the next two excerpts, it kind of builds upon itself in forming this narrative of people are not coming forward. Our job is so difficult. We got to do this to protect the community. We got to do this to protect children. And that's my concern, is pushing that narrative through Gaither's words during these interviews are admitted for the express purpose of Mr. Copeland's prior inconsistent statements.
Let me make a suggestion. Why don't I just listen to the three together, and then we can have another discussion, okay?
Great.
All right. Let's play 40840 to 409, or actually 40840 through 41105.
No, sorry, 40836.
And even if I did see something on Twitter, I can use what Twitter says. You the victim here. That's what you're so used to being in fucked up situations, you don't realize you a true damn victim. When police came to my house, I wasn't no dead. I was a suspect. I can't vouch for what nobody else did. This is my case. This is my case. If you was a suspect, you would have got locked up that night. That night. You admitted to shooting back, you would have got locked up that night. Am I correct? Okay, so I'm asking you, who the fuck shot at you? Either you gonna tell me or you not, or you just gonna stay in this predicament that you in. But you're not helping yourself. And you going to the streets trying to kill you. I ain't even going to the street. I was, if you wouldn't have been told the first time. The first time you would have told me. was joking. What did you tell me the first time? What I tell you? You don't forgot what I told you the first time? The first time that I talked to you a few weeks ago about the incident on the highway, you didn't tell me when was time to tell me, you didn't tell me. Us talking off the record, it's like it never happened. It's like it never happened. And I can't work like that. You expect me to help you, but look at what happened to me. I'm expecting you to help you. I'm getting shot at and locked up. It's like I'm talking to a brick wall, Woody. I try my best not to cry. It's all right to cry. I cried the same night they came. I did. I let it out. But I express every day. You know what? I did shot my car. You know what I was doing? But I was still out. I ran 4-wheelers everywhere. I know. I wasn't riding all right. You know what I'm saying? Because I know everybody wasn't out to get me. I'm not saying everybody out to get you, but the folks that are out to get you, obviously they coming for you. And me as a police officer, if you don't give two shits about your life, I care about your baby life. I care about her life. She can't get my life and my girl's life. Exactly. So help me do this shit. They are protected now. They out there by themselves. But you not telling me nothing, cause I'm in jail. You right here right now. They out there by themselves, and the folks that shot at y'all.
It ended a little bit later at 4:11.
Alright.
Hey, Ron, I have a physical copy of it.
Thank you.
It will be 378 Yankee Bravo 2.
Thank you. All right, sir. Sure.
So, Your Honor, my objection to what the playing of what Investigator Gaither says is that Investigator Gaither, again, not the intended declarant of these statements, these out-of-court statements, is essentially making an argument that the jury will hear that it's a future dangerousness argument. It's an argument that, you're either on the side of the quote unquote gangsters, or you're on the side of the people that are trying to protect children. It presents a false dichotomy, and also it invites the jurors to consider subjects and consider things that are not supposed to be in their purview as the finder of fact. Well, future dangerousness, protecting the community.
Okay, tell me where in this particular, from 359.50 to 411.05 that you want me to invite me to look at for future dangerousness.
I believe it is around 410.55, where essentially Investigator Gaither is saying to Mr. Copeland,
okay,
you're not cooperating.
Hold on one
If
second.
you don't,
You said 410.55?
I believe it's.
Hey, can you give me the page references for that, please?
And it's,
I don't believe that he's saying this. I don't know.
and essentially.
No, around 410. I need to know the.
What page 410?
Yes, ma'am.
That will be around page 28.
All right.
And I don't have the transcript in front of me, the state's transcript, but what the part that I'm referring to is where she says, Woody, you're not talking, you're not cooperating, you might not care about your little girl, but I do. I'm going to protect your little girl. And I think that's improper. It puts again, it improperly presents this dichotomy of where the police are the good guys and the protectors of children away from, the bad guys who are out warring in the streets. And I just believe that that's an improper statement. A, it's not true, but B, it's an improper statement that invites the jurors to consider things other than the evidence in this case.
Okay, you saying that, okay, I'm looking at page 28, line 10 or thereabouts, Detective Gaither. I'm not saying everybody out to get you, but the folks that are out to get you, obviously they're coming for you. And me as a police officer, I don't give two shits about your life, but I care about your baby's life.
Right.
Copeland, I care about her life. Detective Gaither, she can't get Copeland and my life and my girl life, Gaither, exactly. So help me do this shit. And then Copeland, they out now. They out there by self. But they self. But then you're not telling me nothing. That's Gaither.
Right.
And he says, because I'm in jail. And then she goes on to say, you hear right now, and this is page 29, starting page 29, they out there by themselves, and the folks that shot at y'all are probably still out there as well,
In my most strenuous objection is just about the comments about protecting his daughter. I don't think that's appropriate.
All right, any other portions that you want to point? Are you saying that the entirety of it, or are you just saying that particular section?
Right, that particular section about the child, and I think that fails under 403. Not probative. Again, it's the investigator talking, so she doesn't have any personal knowledge of the facts of this case. It's not really the witness presenting evidence, and again, I think it's confuses the issue, and it's likely to inflame the passions of the jurors, and it's prejudicial to our clients.
Well, if there was some testimony that Mr. Copeland was in a vehicle with his significant other and his baby,
Outside of his house.
and they were shot at.
Yes, this is
They were shot at.
Exactly.
So I'm sorry.
This interview, just for context, is 2 days after that.
Yes. So, I mean, it's not. I mean, she's got some basis to ask him those particular ask him or appeal to him in terms of what he, what's going on in his life and her investigation. Like, don't you want to get at the folks that, or at least tell who it is that shot at you?
Well, let me.
Because she's investigating.
I'm not
correct?
criticizing her questioning of Mr. Copeland. Of course, yeah, she has the right in the interrogation room to appeal to whatever she wants. I'm just saying not every, even if it's quite honestly, even if it's decent interrogation techniques, doesn't necessarily mean the words of the officer are exposed to the jury. And that's my issue. I'm not saying that she broke any rules in the interrogation. I'm just saying that those appeals are not necessarily appropriate to expose to the jury.
Can I respond?
Okay, tell me again how it's future dangerousness?
Well, it's an improper appeal to protect the community. It's creating the impression in the juror's mind that the police are out here protecting children, and that these gentlemen in this back and forth between Mr. Copeland and other individuals, and the state would say individuals seated back here, and this other group are putting these children at risk. And what I'm saying is, if Investigator Gaither was on the stand and said, you know what really bothers me about these things that I've been investigating all these years, it's that these bullets come out of these guns and they're coming at children's heads. We would all jump up and say, objection, objection, that's improper. What is she saying on the stand? So I don't know why it's allowed in just because it's on a tape as an out-of-court statement. It's still making the same appeal.
I don't think she's making a general, I don't think she being Gaither, I don't think she's making an individual appeal for protection of the community. I think she's making an individual appeal to him because he's the victim of a crime, a purported crime at that point in time. So, but I've heard your argument. I haven't made a decision as of yet. State?
Yes, Your Honor. So I want to address a few things. First, this future dangerousness argument is not a proper argument for what occurred in the interview room. Future dangerousness solely talks about an open and closing argument referencing to the jury that if you don't find these defendants guilty, then this will occur in the future. That is what future dangerousness references. It has no bearing on an investigator who's trying to investigate a crime, appealing to the victim as to why he should come forward with who harmed him. That is what Detective Gaither was trying to do. Secondly, Your Honor, the defense early in our trial made a number of cross-examination efforts to talk about police officers and the fact that they only target a community, that they only arrest certain types of individuals. And what this video shows, most importantly, is that she was trying to get Mr. Copeland to identify who did this. But secondly, that the police aren't just trying to arrest people. They are not just trying to get individuals charged with crimes, but yet they are trying to investigate crimes, hold individuals accountable, and make sure that those who are victims are no longer victims. And so what Detective Gaither is doing in this portion is trying her best to appeal to Mr. Copeland, who has some concern about giving up an individual, who is concerned about snitching. And that's what you're going to see later on in this interview. And she's trying to get him to identify who did this to her, who did this to him and his child and his child's mother, Your Honor. And so given one, Copeland himself on the stand says, in all these interviews, they were just out to get me. They were out to get Thug, they were out to get me. This is a complete contradiction to that, because Gaither isn't trying to get him. Gaither isn't trying to just get Thug in this interview. Literally, she's trying to identify who shot him. So one, it's impeachment by contradiction to show Gaither's, how Gaither was interacting with him. Two, she was trying to get Mr. Copeland to identify who the person was that he saw shoot at him. She can use certain investigative tools and tactics. Mr. Steele said yesterday, all day long, I want to show that this is how they investigated cases. Well, this is a part of that. This line of questioning is how they investigated cases. And when Mr. Steele says, well, I want to show these bad portions of it, then this is in contradiction to that. This is her using her investigative tools in order to get a victim to come forward. So for that reason, it should come in. And then this future dangerous argument is not relevant for what occurred in this courtroom. So for those reasons, Your Honor, we would ask to play these portions of the of
Okay.
the recording.
All right. Anybody else other than Mr. Sharp wish to be heard on this, on the first three redactions? 35950, 40020, or 40840 to 40940, or 41055 to 41105. Anyone else? Mr. Weinstein? Mr. Matthews? Ms. T. Williams? Mr. Harvey? And a 105 instruction. Okay. Denied, but I've noted it, sir. I'll give you a continuing objection on that issue, okay? All right, Mr. Steele?
No, I'll stop what was said.
All right, sir. Okay. For the reasons articulated by the state in terms of identification or impeachment by contradiction, I don't believe that future dangerousness applies for this particular portion of the transcript. I'm going to authorize or allow the state to play those particular portions over objection. I'll give you all continuing objection as to that. All right, can we move on to 41130 to 41235?
Yes, Your Honor, I'll just keep on playing from where it stops.
All right,
And Your Honor, for reference, that's page
yes.
29, line 9, through page 48, line 11.
What will that take us through?
That's going to take us through 41235.
Oh, okay, that's the fourth area of contention, 41130 through 41235.
Yes,
Okay. All right. You can go ahead and play it, please.
Still out there as well. Probably still out there as well. Still in jail. Oh shit, man. I try my best, man. Cause guess what? If I help you, if I tell you anything, guess what? They make it even worse. What make it worse? Everybody, oh, now I'm snitch, now this and that and that. Bro, how you a snitch for somebody trying to kill you, the girl, and your baby? That's snitching. I just want to get out of jail and go to my next job. Just stay out of the way, man. I'm ready. But do you honestly think somebody else that quote unquote the good guy gonna want to help you? If you ain't telling us like you talk about snitching and all this, it ain't about that. But as long as you out there being a part of the problem, we're gonna let you be a part of the problem. I haven't been a part of the problem. You are. You're not trying to resolve the problem at hand. And I told you the only way for you to start resolving, to get this shit started and resolving it, is you gotta talk to us straight up. That's it. You gotta talk to us straight up. Because if you're not, it's just gonna continue and continue and continue. And I hate to see you or anybody else come up there behind some foolishness because everybody want to be loyal to the streets and everything. But y'all want to say, care.
And that ends at 41236.
Okay. Mr. Sharp?
So my issue with this, and again, it's going to be under 403. My issue is this: the state is clearly making the argument and trying to appeal to the jurors through their questioning, and I'm sure they're going to make arguments in closing. They made arguments in opening that witnesses are reluctant, that Mr. Copeland's reluctant. They're pointing out that Mr. Copeland says certain things when Jeffrey Williams is in the room versus not in the room. And the reality is, despite insinuations at times by the state outside the presence of the jury, that were unfortunate accusations, I think, there's been no evidence that Mr. Copeland fears anyone seated here. There's been no evidence of any threats made by anyone seated in this courtroom towards Mr. Copeland, or at least on the defense side. So here, Mr. Copeland is clearly expressing fear of being a snitch, being labeled a snitch, the ramifications of telling. But what's important here, and I'm afraid what might get lost, is Mr. Copeland is expressing fear of an entirely different group of people than the accused here today. He's expressing fear of the group of people that are shooting at him actively at the time of this interview, which I think the state has alleged are if gang members. I believe that certain individuals that are not associated with any of the defendants here today were arrested and charged with that crime. So it's misleading the jury. It's confusing the issues because I think Mr. Copeland is expressing a reluctance to cooperate out of fear being labeled a snitch, but it's not. It invites the jury to conclude that he's afraid of these gentlemen, and that's not what he's saying. And yes, I understand that we have the ability to cross-examine and those issues, but Your Honor, I just ask for you to consider the logistics of this case. The fact that the state is talking about playing, like, I don't know if we add them up, 17 hours of videos or however long of Mr. Copeland. There's it's not a typical trial where we get to just follow up with cross and clear up issues. There might be a week between when this is played and when we have the opportunity to cross-examine him about these issues and clarify some things and clear them up. And it's kind of like it's just not a smooth process. And I think that we need to do our best to eliminate any of the misleading or confusing issues from this tape, including this segment right here, which under 403, I believe that it should be excluded.
Okay, state.
Thank you, Your Honor. I think Mr. Shard is trying to compartmentalize issues, and we have to look at this case in the totality of all of the circumstances. So first things first, specifically, when I asked Mr. Copeland on the stand about Tay and about whether or not he saw Tay shooting, he said, again on the stand, he didn't do it. I swear to God, he didn't do it, or whatever his frame. I'm not quoting that as a direct quote. But also, he talked about not being afraid of snitching. He talked about the fact that whatever he said in these interviews, he was just saying it just to say it. I asked him, was he concerned about snitching, being labeled a snitch? He said, I was not. So this is impeachment by contradiction and prior inconsistent statements, both. Because I, on direct examination, asked him, was he concerned about snitching? He said, no, I wasn't concerned about snitching. They were forcing me to point out Tay. They were forcing me to do it. Gaither forced me to point out Tay. This is in complete contradiction. He literally talks about why he cannot identify Tay because he's going to be labeled a snitch. I believe this is the interview. Later on, he talks about the fact that his cousin was labeled a snitch and what happened to his cousin. So this is one in direct contradiction to that specific line of questioning. But also, Your Honor, snitching is relevant in this trial in the totality of the circumstances. Mr. Copeland literally last week or 2 weeks ago decided initially that he was going to plead the fifth in order not to testify in trial. To testify into trial is snitching. He has now, as a course of his conduct in the last few weeks when he has testified, is now completely contradicting everything he told police when these individuals were not in the interview room. Again, that is snitching. And here is a reason he is explaining in 2015 why snitching is a problem. So when you look at it for both the specific impeachment of my line of questioning about this interview, but then the larger conspiracy, in this case, people do not want to come in here and testify. Mr. Copeland is not the first witness. We've had Ms. Archillian Bennett, who testified that what she never talked to the police or what she told the police was a lie. But then when you come into court and have to face the individuals that you were accusing, have a different story. Same thing with Adrian Bean. Adrian Bean had a whole interview with Detective Quinn, identify Mr. Williams, identify other individuals who participated in a crime with him. But when he came into court, did not testify. So therefore, snitching is an issue in this trial. Mr. Copeland is talking about his reasons for not wanting to snitch, which is very relevant in the totality of this case. So for multiple reasons, we believe that this portion should be allowed to be played.
All right. Any other councils wish to be heard on this particular issue from 4/11/30 to 4/12/35? Mr. Weinstein?
No, no.
Mr. Matthews?
No, Your Honor.
Ms. D. Williams? Mr. Harvey?
It can't be impeachment, because it was made at a time when, the witness had a motivation to lie, even after this particular event occurred, so it can't be admitted for that purpose.
All right, okay. All right, sir. Mr. Steele?
Just as the court goes through your ruling, the state's information, for what they just said about people come in and then face Mr. Williams et al. And then are reluctant, is not what I understand. I understand Ms. Bennett was upset because the district attorney's coworker was inappropriately communicating with her. I understand that Mr. Bean told another detective at the hospital when he was first arrested that he did not have information. He was told, if you include Mr. Williams, then you can get out. It will be better for you. With Mr. Copeland, who's testifying, he has stated that he's been pressured by the prosecution. So this whole creation of pressure is a theory of the district attorney without zero proof. So I don't believe that should weigh into your analysis at all. I also agree with Mr. Harvey that once the reason for the fabrication or the improper influence is birthed, then under Tome, which is T-O-M-E, United States Supreme Court case, and in Georgia, Adams, A-D-A-M-S. It's also in the statute, which is OCGA section 24-6-613, because the motivation of Mr. Copeland is clear. He's in custody. He wants to get out of custody. And he's making statements. These are not prior consistent statements at all. The state is saying it's prior inconsistent statements. Sometimes they are, but sometimes they're really prior consistent statements that they wish to get in, because Mr. Copeland really is not inconsistent. He said, yes, I probably said these things, but I said them because I was motivated to get out of jail. So the state is relying on inconsistency. I believe that they're really relying on consistency, and I join Mr. Harvey about it's not proper for a prior consistent statement.
All right, sir. Okay. In considering 4/11/30 or thereabouts to 4/12/35, the court is in agreement. At least it's impeachment by contradiction for the reasons that the state's proffered. Whether or not the issue of snitching is relevant before the jury, and whether or not that is an issue that several witnesses have testified to would be relevant. So, but the court's primary ruling is based upon impeachment by contradiction. So that will be authorized to be inquired into. All right. Let's turn now to 4/25 to 4/25/33. Casey talking about Shannon beefing with IG people. You can flesh it out, sir.
So just a little context, Your Honor.
All
This is after. Obviously, you know, this is after the episode of Mr. Copeland being shot at outside his house. It's also after a January 28th episode where we've heard testimony of Mr. Copeland Demekion Garlington and Mr. Stillwell were all in a car together, and that car was shot at, and the car stopped working, if you recall that testimony, Your Honor. So there's two different shooting situations involving Mr. Copeland, one where Mr. Stillwell was also apparently or allegedly in the car. And Mr. Copeland is, I believe, making reference to Mr. Stillwell having issues with some of Mr. Copeland's enemies on Instagram. My objection to this is that this is based, Mr. Copeland's in jail, and it's unclear how he's aware of this, but apparently he's been told about Mr. Stillwell having back and forth with these individuals. From my recollection, I've been through all the discovery numerous times. I don't recall in discovery seeing any of this alleged back and forth during this time frame involving my client on Instagram. So I haven't seen any documentary proof of any of this, so I don't know exactly what Mr. Copeland is referring to, but from my understanding of the context of the statement, Mr. Copeland is merely passing on hearsay information about what Shannon is doing on Instagram.
Okay.
Mr. Copeland does not have access to Instagram, obviously, as he's making these statements.
All right, can I hear it, and what transcript page is this from?
It's going to be page 47, but page 47, line 9 through page 48, line 15. But I do think for context, we need to start at 424, which is going to be page 45, line 25. Page 45, line 25.
Page 45, line 25?
Yes,
Okay. All right, go ahead and play it, please.
I tell you what I'm talking about this. I'm not like, I did see her face. It did. When I see him jump out the car. Kind of favor somebody. Who? The boy that was showing at my house. Who? Who? Who you know to be driving that silver Bonneville? I could never picture that. That's something I could never get. So who do you favor? Tay. Your friend Tay? Which Tay? Well, boy, my partner at the moment. Where you from? Simpson. You from Simpson? How can I find Tay? He on his Twitter arguing with Shannon. He did what? He's on Twitter arguing with Shannon. He on Twitter arguing with Shannon. This recent? Yeah. When? Right before y'all came and got me, I was just on the phone with my baby mom. She just told. So him and Shannon on Twitter arguing? They been arguing. About what? Me. Saying it. You still alive because we miss you. You still alive because we miss you? Like they miss, like we shooting at you? When did you see this person, like before the incident the other day with your baby? Before the incident with you and your baby, you said the dude was shooting at my house. Which incident are you talking about? Huh? You said the same boy that was shooting at my house. Okay, which?
Can you write in that 425, 49?
Okay. Yeah.
So I heard it, and I'm assuming Your Honor heard it. He says Tay, and they're trying to figure out who Tay is.
Which Tay?
The Tay, I don't know which Tay at this point.
Okay.
There's a Tay that allegedly shot at Mr. Copeland, or that's the state's theory, and Mr. Copeland is saying Tay, but he's not identifying Tay. and he says something about that Tay is having an argument with Shannon on Instagram, and then he was like, when is this happening, is what Investigator Gaither asked. And Mr. Copeland says, essentially now, or when I got locked up, and he said, that's what my baby mama told me. So it's clear his source of information is someone else who's telling him about this alleged internet argument, and he doesn't have any personal knowledge of it.
All right, sir.
It adds absolutely nothing to the context of this statement, other than it brings in hearsay evidence about my client, which I object to.
All right.
You're right, the section about Twitter, we won't play, we'll just pick that up when Detective Gator's trying to clarify, Mike, they missed you, when was he shooting at you? Just to try to clarify that portion, but we will take out, I think it's probably about 425.
425.31 to what?
No, 425 to 425.
Okay, 420. 425.20.
No, 425.00
Yes, ma'am.
to 425. I think it's about 31 or 30.
31, 32. That's what you said you're gonna take out? Because that talks about the Twitter conversation. All right. Mr. Short, anything else from that particular time block that you wish to be omitted?
No.
All right, any other council wish to be heard about anything from 425.00 to 425.33? Mr. Weinstein?
No, Your Honor.
All right, Mr. Matthews?
No, Your Honor.
Ms. T. Williams? Mr. Harvey? All right, Mr. Steele?
No, nothing further.
Okay, all right. So the state will be directed to omit that particular portion. The rest of it can be played. All right, let's move on to 6, and that would be,
This next is. it's a
hold on,
very-
let me just frame it right quick, sir. 438.35 to 38.40. And you've indicated that Casey saying that he has not hung out with Shannon Lodi since they shot the car. Confusing under 403 is a pronoun they is meant to refer to people shooting at Casey, Shannon Lodi, but could be misconstrued.
Right.
Okay.
So
Go ahead.
essentially, they are asking about when's the last time he hung out with Shannon and Lil D, who's Demekion Garlington. And he says, not since they shot at the car. I think any reasonable interpretation of that, based on someone who's spent hundreds, probably thousands of hours reviewing the discovery in this case, which I have and the defense counsel has, any reasonable interpretation would mean he's referring to is the people that shot at him, Shannon, and Lil D in the car on January 27th, I believe it was, the day before the statement on the 28th. However, the jurors have not gone through all the discovery 10 times over as the defense has. So they have limited knowledge of everything. And when you listen to the statement in a vacuum, the reasonable interpretation is he hasn't hung out with Shannon and Lil D since they shot at the car, which makes it seem like Shannon and Little D were shooting at a car. It's confusion of the issues. It's likely to mislead the jury. And again, Your Honor, this is another one of those things I said earlier. This is not a normal trial. Yes, theoretically, first of all, there's no need to bring this confusion into this trial. So there's no prosecutorial need for this little excerpt to be played. But sure, theoretically, we could clear this up during cross-examination under normal trial circumstances. But when this is played, there's going to be several days in between that time where the jurors are likely to have in their head, if they're scrutinizing every line, oh, wait, Shannon and Lil D were shooting at a car, you know, and that's going to affect the way they look at my client. And when, in fact, we can just clear that up at the time of him saying it by deleting it, as opposed to me having to come back days later and try to clarify and draw everyone's attention back to this incident and this statement. So I just think under 403, to avoid confusion of the issues, we could easily just redact this little segment and clear up any potential confusion.
Yeah, you're right. Before I even play it, the state understands what Mr. Copeland is talking about when he says when they shot at the car. The state has no intention of alluding that the they is Mr. Garlington and Mr. Stillwell trying to shoot at Mr. Copeland. And when I read this portion, I'm going to play for the court the entirety of that section, because I think in order to understand this section in context, you have to start at 438:14, because there's already evidence, or will be before this video is played, that there was a shooting on the highway in which Mr. Copeland was involved in. And the state in no way, shape, or form intends to infer that Mr. Demekion Garlington or Mr. Stillwell was trying to shoot at Mr. Copeland. That's not even something we thought of. So we'll play the whole section so you can hear it in context.
Fine. Can I get the page references?
Yes,
too,
Your
please,
Honor.
Madam?
We're going to start at, it's going to be roughly page 64. And I'm starting at 438:14, so it should be around line 2 on 438, on page 64, line 2. And it will go through page 65, line 1.
All right, madam. All right, let me hear it, please.
In that fucking river with them, period. This is what is going on. These two people I be with, they're gonna be Shannon and Lil D. When I'm making with Shannon, me and Lil D together all the time. That's exactly. You know, this Shannon still with Demekion Garland. Yeah. Me and him together all the time. They're the only two I been with. Since they started their car, I've been in the house with my baby mama. If I ain't in the house, we don't got to hug, and I don't call Queen. Queen can't pick that up, and we just rolled around here.
So we stopped it at 438:46. So in context, he's talking about the last time since they were shot at in the car. Well, before we played this interview, we would have played the January 28th interview where he's going to talk about the fact that they were shot at in the car in January 28th. And so when you read those two in conjunction with each other, I believe the jury will understand that he's saying since they got shot at the car, I've been in the house, given the full context. And again, the state will not infer that the they is Demekion, Mr. Garlington, Mr. Stillwell shooting at Mr. Copeland.
Okay.
When I said the defense attorney's been spending a lot of time with this case, also the state has. I mean, they have a background understanding. Both sides have a background understanding that's through discovery that's deeper than what the jury has at this moment. And that this line adds nothing to the understanding of the case. But, you know, I just listened to it again. I was thinking maybe I missed something. He says, there's no discussion of other people shooting at the car. They say, when's the last time you hung out with Shannon and Lil D? Not since they shot at the car. I mean, it sounds like my client shot at a car.
Well, it has to be taken in context because the jury's already heard about some purportedly shooting. Okay.
Yeah, but
I understand your concern under 403. I respectfully disagree at this point, but
okay.
Because I don't think it would confuse them. But anyways, anybody else wish to be heard on this issue? Mr. Weinstein? All right, Mr. Matthews, Ms. D. Williams, Mr. Harvey, Mr. Steele. Okay, all right. I'm gonna admit it, or allow it to be played over objection. I still give you a continuing objection, okay? All right. Let's turn to number 7, and number 7 is 60325 to 60605. And you,
By the way, it's page 155, line 1 through 156, line 155, line 1 through 156, line 24.
So
okay, Mr. Short, the- all right, let me frame the period. It's 60325 to 60605. It alleges Casey talking about Kel shooting and at some dice
at a gambling spot,
gambling spot.
which I believe under the state's theory is kind of one of the incidents that's the genesis of everything, of the disagreements between the groups. And my objection is that Kenneth Copeland is basically telling the police that Kel shot up the gambling spot, but even in his own statement, his identification of Kel, now, let me be clear, he does say he was there, so it's not that he wasn't there, but from my understanding of his statement, he didn't know, no one knew who shot up the gambling spot. No one identified Kel, who's Kelvin Watts at the time, but afterwards, apparently, according to Mr. Copeland, Kelvin Watts told his girlfriend, or a girl that he knew at the time, whose name's Trivia, about what had happened, and apparently made some confession, according to Mr. Copeland. And then Trivia tells Kenneth Copeland. So it's double hearsay. And certainly, even if Kelvin Watts to Trivia would fall under a hearsay exception, Trivia to Kenneth Copeland would not fall under a hearsay exception. So it's hearsay, and he doesn't have a basis of knowledge, and we would object to its submission.
All right, State.
Your Honor, the information about the gambling spot has already come in based on the January 11th interview, in which Kel discusses, if not January 11th, February 20th, but the 2 interviews that have already been played before the jury. Mr. Copeland has already said in both of those interviews that there was this incident at the gambling house in Lakewood, and that it was Kel who did it. And more importantly, when he met with Kel at the Cascade skating ring, maybe the next day after this gambling incident, that he talked to Kel about the shooting at the gambling house, and that it was during that meeting at the Cascade skating ring that Kel got on the phone with Mr. Williams, and Mr. Williams asked for Kel to pay for the window that was shot up at the gambling house. So one, the evidence is already before the jury about the gambling house. how we get to who told him is irrelevant because it was the effect on the listener, meaning Mr. Copeland, that once he gathered this information, he's using this to try to squash the issues between Copeland and Kell. And so when he's relaying to Detective Gaither the beginning of the conflict between him and Copeland, he's just now reiterating how he got the information that Kell did it and what effect that had on the issues between the two of them. So who told Mr. Copeland that it was Kell is irrelevant to the sole fact that he thought it was Kell. That was kind of the beginning of their issues with each other. And as a result of knowing that it was Kell who did the shooting, Copeland in turn confronts Kell about this shooting. And during the course of his confrontation of Kell, also had a conversation between Kell and Mr. Williams about the shooting that occurred. So this portion as to how he found out it was Kell is not, while hearsay is really effect on the listener, but this is already information that's before the jury. But it's important, Your Honor, because let me say this, that defense counsel is arguing that Copeland consistently lies. What this shows is that Copeland's giving the same series of events to multiple different investigators at multiple different interviews. And so that shows that at least back in 2015, when he's recounting his history with him and Kell, he's telling different investigators these same series of events that occur leading up to the murder of Donovan Thomas. But I'll play the section for you if you want to.
All right, sir. Yes, ma'am. Go ahead.
And I'm going to start at 6:03:22.
But that's what it was about. Then they got mad. The D got jumped in the club by NBC. They tell the D, we ain't got you because you be with them. They asked the D, why they ain't got you? I don't know why. It was no, but the whole time they gonna kill them because this is a gambling house we go hang it and gamble. We go there and gamble. We come out the league. Kill them in the bush. Kill Stewart, and they never mentioned the third person name. In the bush, they started shooting them. They shot so many times. Yeah, I was glad they left. In Lakewood. They shot so many times. They shot down in everybody's car. But they missed everybody. They graded one person across the back. But when police can't hear, left. Co-people left. But they were killed. But this is the same like NBC jumped on the D. So they did it and they seem like NBC did. But I go over, boy, I'm home. I stayed out about 2 or 3 years. So I was telling them like, damn, bro, y'all niggas come on there, y'all trying to kill me, what's up, bro? And they like, hell nah, bro, you tripping? Like, bro, we ain't see that y'all did with one of the NBC niggas. Like, bro, we ain't got no problem with that, bro. You didn't. Y'all trying to let D be with me, bro. I'm on the stage. I was like, nah, bro, y'all tripping, bro. In my palm, bro, nah. They keep trying to get in each other's face. But nah, the next thing knows, Big Boot came on down, and one of them, swarm. He grabbed the D off stage, started jumping on the D. I ain't know it was a D. I'm thinking they wanted them jumping on them. So I walk out the club, see the D, him got shot in the hand, and he blamed me shit. What's wrong with you? What happened to you, bro? And he couldn't talk. He like, and I was seeing the hammer, but damn, they shot you too. So he went down hammer now. He went to the hospital. I had to tell him I'm with him. Then Pinky went down there with him. Goddamn, the next night we had gambling house. They ain't not putting no pictures. We in that gambling. They take pictures and shit. Then he came up and shot at it. We found out it was killed. He had got into a Gucci Red. And she was talking to them. She came back and told her, like, man, they were killed and shot at y'all. Makes it like they did. Because they shot at it and they went and shot at Monday spot. Monday we got into it with the NBC name. They bumped, boom. They how they fight started. They went shot at their house on Metropolitan. 下考都是，是的。
And it ends at 6:06:07.
So to put a little context to what you just heard, this gambling spot was shot up, according to Mr. Copeland. It was assumed that it was people from a group called NBC, because according to Mr. Copeland, Mr. Kendrick had gotten into some sort of dispute with someone from NBC around that time, is what Mr. Copeland's saying. I don't know if that's true or
Mr.
not.
Kendrick or Mr. Garlington?
Mr. Kendrick. I think he says Monte. I'm assuming Mr. Kendrick. Might not, maybe someone else named Monte. And I don't know if any dispute occurred. But what he's saying is it was assumed it was NBC. And then through hearsay, it came out that it was Kel. Through hearsay, through trivia. And so our stance is that's hearsay. Effect on the listener is much narrower an exception to hearsay than the state's been putting forward in this case. Throughout this case, they've been relying on effect on the listener quite a bit. I don't believe that it's quite as easy to get around the hearsay rules under just saying effect on the listener. And his knowledge, he's giving a historical narrative of this event, and his knowledge of who committed the event or committed the act is based entirely on hearsay. So we
Okay, what about the issue that we've heard testimony already about the gambling?
then
house
it's
and the
cumulative.
And the shooting of the gambling house.
Well, if we've allowed that in the past, then that's on the defense counsel for not flagging that. But at this point, it's cumulative if it's come in already.
I believe it's already been testified to. In fact, I think Mr. Copeland earlier in his direct he's testified about that on the stand, about the shooting of the gambling house and this
Well,
this kind of historical perspective.
At this point, then it's cumulative, and you know, if collectively we have missed it in the past, we're flagging it now.
Okay, all right. Any further argument, Mr. Weinstein?
No, Your Honor.
Mr. Matthews?
No, Your Honor, just a thought.
Ms. T. Williams? Mr. Harvey? Sir? Turn your mic on, sir, please.
I want to adopt what Mr. Shard said with regard to the effect on the listener. Effect on the listener is usually most often used to as evidence of motive. It has not been used in that sense, and therefore it has been abused and continues to be abused as the basis for the admission of these clearly hearsay statements. So, for example, in Gates versus the state at 298 Georgia 324,
One more time, Gates?
Gates 298 Georgia
All right.
324,
Yes, sir.
there were text messages admitted that were sent to the defendant's girlfriend, not for their truth, but for the effect on the defendant in establishing motive for a murder. That's the usual basis upon which hearsay statements are admitted for the effect on the hearer. That is not the case here. This is not the defendant. It doesn't establish motive. So I would adopt and expand Mr. Shart's reasoning.
All right, sir. Mr. Steele.
Nothing to add.
All right, sir. Excuse me. All right, folks, we're gonna take a comfort break. Let's take 5 minutes to come back. I'll make a ruling at that point in time on 7, okay?
And Your Honor, before, the state did want to respond to what Mr. Harvey said, and so I didn't know if we could get an opportunity to do that prior to the court's ruling.
Okay. All right, we're in recess. You said you had a response to Mr. Harvey's comment.
Yes, Your Honor, very briefly. In looking at Gates, Your Honor, specifically the portion which they talk about the effect on the listener. Yes, this was a murder case, but what it says, and this is in Division
2,
2,
I have it up.
yes. And when you read the fullness of it, it says, for a statement of constitutional hearsay, it must be offered in evidence to prove the truth of the matter asserted. And it cites the statute. Here, the declaring statement at issue was, you're ever lonely, you can call me. The text message sent along with the naked pictures was not offered to prove that Gates' girlfriend could in fact call or had permission to call Wilson if she were lonely. Rather, the text messages were offered to show its effect on Gates and in this case, his motive for committing the murder. An utterance may be admitted to show the effect on its hearer. See also Miller v. State, 275 Georgia 32. For such a purpose, the statement would not be hearsay as it was not offered for the truth of the matter asserted, but for the effect or lack thereof on the hearer. As such, Gates claims that this evidence was inadmissible because it was hearsay without merit. Here, again, Your Honor, learning about the fact that Kell shot at the gambling house, what Copeland took with that information is he confronted Kell about it. They had a discussion about not just the gambling house, but all their other issues that they had with each other. And then furthermore, during this interaction, which was, I believe, the next day after the gambling house or some time later, Mr. Williams then speaks to Kell about that shooting that happened at the gambling house and specifically about paying for the window. So again, Your Honor, it's not about what, and I believe it's Gucci Red. I think Mr. Shar said that it was Trivia who said it, but I believe he said Gucci Red told us it was Kell. That information is what he used to confront Kell about about what happened at the gambling house. So that's what the state wanted to add.
What's your response to the defense's assertion as well as cumulative? Because it's been testified to.
Because, Your Honor, defense counsel assertion is that Mr. Copeland lies about everything. And so what his reiteration of this incident shows is that not just in the February interview, not just in the January interview, January 11th, he talks about it, I think briefly in January 28th and February 20th, that he's reiterating these events to different investigators to talk about the history of what has occurred between them. And if he's such a liar as they want to purport him to be, then he would not be able to recount this historical perspective to the detectives that he is meeting with. So while he is repeating the story, he's repeating it to different detectives at different times to show that he is at least consistent with the historical events that lead up to Donovan Thomas's murder.
All right. Okay. All right, councilors, I've had an opportunity to consider your arguments as well as take a look at Gates 298 Georgia at 324, as well as Garner versus the state at 342 Georgia Appeals 824. Both of them stand for the same proposition about effect on listeners. So I'm going to permit that to be the inquiry area of 60325 to 60. Hold on. Get back. Hold on. (60325) through 60605. All right. I'll give you a continuing objection, defense counsels, as respect to that. Let's move on to 8. I believe 8 is 6/19/20 through 6/20/20. And I believe that is Casey being reluctant to cooperate in the shooting investigation where he's a victim. He says He's concerned they would put the discovery on IGS or Instagram.
Yes.
Okay. Can you
So-
give me the page references, Mal?
Yes, Your Honor. So page 173, line 7 through page 174, line.
Okay, all right. Mr. Sharp?
So, Your Honor, here is another example of Mr. Copeland stressing the social ramifications of cooperating in this investigation. Again, when I say this investigation, I'm referring to an investigation against people that shot at him allegedly outside of his house while holding his child. So we get into this, it's almost bolstering, it is bolstering, where he's showing a fear of testifying, but again, it has nothing to do with these gentlemen. It has nothing to do with the investigation of these gentlemen seated in court today, but it has to do with an entirely different group of individuals from that are allegedly associated with an entirely different group. So it has no relevance to this case. It creates the impression that Mr. Copeland is universally opposed to cooperating, universally fearful, universally has been threatened and feels threatened. But the reality is he's expressing fear, reluctance, and all the rest regarding an investigation of an entirely different group of individuals. And it's likely to confuse the issues. It's unfair prejudice towards our clients where there's absolutely no evidence that he's been fearful, that he's been threatened by any of these gentlemen or anyone associated with these gentlemen. So we would argue that it should be excluded under 403, 401 and 403.
All right, madam, can you play it, please?
And Your Honor, I'll start at 6/19/40.
You know my name? In that car that's gonna put them there. Like you worried about the wrong thing. Like, I'm worried about when you get locked up and you get a skirt, they get to see I circle each picture and put my name on them. You're gonna send it out to the screen and be like, I done told on him. And they're gonna put it out on Instagram and Twitter and they're gonna tell everybody. And then guess what? They're gonna start like, damn, I'm gonna be just like what then? Nobody won't be around. So you worried about your reputation as opposed to your life and being a free man? It's up to you. I don't want to go back and forth. You gonna do it or you not?
And Your Honor, that's the conclusion at 6/19/44. And Miss Weaver, we start at 6/19/06. And Your Honor, oh, may I respond?
Yes, ma'am. What's the state's response to Mr. Shard and the defense attorney saying that that violates 401 and 403?
So again, Your Honor, one, this is a impeachment by contradiction. Again, in court, Mr. Copeland has said repeatedly that they forced him to pick out Tay, and that he was not afraid of snitching or telling the police who did it, but that Tay did not do it. So one, this is a contradiction to both of those assertions that he made in court. Here, again, for the totality of the case, Mr. Copeland, back in 2015, and we believe even now, does not want to come to court to testify against whether it was Tay or these individuals. So this shows, one, he contradicted his testimony as to what he did back in 2015 as it relates to Tay. And then two, it shows Not that he's fearful that anyone's going to harm him, because the state has never asserted that any of the defendants were going to harm him. What the state has asserted is that he does not want to come and testify against them. And this is a prime example of that. So for those two reasons, we believe that this portion should come in. Additionally, Your Honor, when Mr. Shar says this had nothing to do with this case, that is not true. What Mr. Copeland is talking about in this interview is a retaliatory shooting that occurred as a result of Donovan Thomas being murdered. So again, putting this all in context, Mr. Thomas was shot and killed on January 10th. Over the course of about 6 to 8 weeks, there are multiple shootings. We went over that yesterday, Your Honor. And one of the final shootings was on February 19th, when these group of individuals that were associated with If Gang shot at him, his child, and his baby. And they're trying to get him to identify who one of those individuals were. So it does have something to do with this case. It has something to do with the overall retaliatory shootings that occurred as a result of Mr. Thomas being murdered. And again, in this section, he talks specific about having to come to court. Like, that was his concern here. Like, I have to come to court and I'm going to have to testify about this. He was concerned about doing that. And Your Honor, we believe that that is also why he's changing his testimony in court today. Court during this trial.
Any further argument, Mr. Weinstein?
No, Your Honor.
Mr. Matthews?
No, Your Honor.
Ms. D. Williams? Mr. Harvey? Mr. Steele?
Nothing.
Okay, all right. All right, in considering both sides' arguments in regards to defense 401 being relevance, 403 being unduly prejudicial, or in the state's assertion that is impeachment by contradiction, the court does find it is relevant that even using 403 as a balancing test, it is more probative than prejudicial and shows impeachment by contradiction. So I'm going to allow it over defense objection, and I'll give you a continuing objection in regards to that. All defense counsel. All right, let's cover number 9. Number 9 is 626:30 through 627:05. And as you framed it, Gaither gives speech about the need to put an end to the shootings. All right, sir, go ahead.
I was gonna,
You want to play it?
yeah, can we just play it and then?
Yes. And Your
Sure.
Honor, it's page 181, lines 8 through 12. And we'll start a little earlier at 6:26:22.
I can't deal with this shit, man. And I understand that, but you gotta help you right now. We trying to get a stop to all this back and forth shooting. You trying to back and forth shooting? Gee, they only shooting at you. Shit. We trying to get a stop to this. And we pulling every resource in the city that we can, but we can't be everywhere. So if I gotta pick these motherfuckers off one by one, waiting on evidence to come back, then I'm gonna do what I gotta do. But you gotta fucking, I'm doing what I gotta do, man. Help me out. I'm doing it. Damn, man. Why did I go through this, man? I don't know. I don't know, but I'm in the do with it. Bruh, I'm ready to get started on the aftermath. I'm ready to get started on that. I can't work towards homicide. I'm picking up the pieces of the aftermath for the homicide. Here.
Your Honor, we stopped at 6:27:30.
So, Your Honor,
All right, sir.
my objection, again, these statements are allegedly prior statements. I mean, the reason we're playing for the jury over our objection, the defense objection, is because they're prior statements by Mr. Copeland. We have the non-declarant, Investigator Gaither, just talking about the need to end the shootings and how she's going to end the shootings, and the city's putting every resource into ending the shootings. And it really, you know, we're all citizens here. We're all city of Atlanta. We're all Atlantans. It's not the city versus these gentlemen. It's not supposed to be the police force in the city versus these gentlemen. And it's supposed to be a neutral. And that's the impression that the jury is given when they're exposed to, again, this speech. I call it a speech, but whatever you want to call it, by Investigator Gaither, where she presents this as, look, it's, you know, the city and all the authorities and the police department, we're all working to try to put an end to these shootings, and it's you guys and Mr. Copeland, it's your information that will put an end to it, and it's your group that's involved in all this. I believe it's inappropriate. I believe that it invites the jurors to consider it invites them to take into consideration factors that should not be considered in that jury room. And it's essentially an improper argument. If it was made during closing, we would argue that it's an improper argument. It's, you know, just because it's not a closing argument doesn't make it not improper. It's improper for the jurors to hear that type of talk by Investigator Gaither, especially considering the whole reason that this tape is being played over our objection is not for Investigator Gaither's words, but for Mr. Copeland's.
All right. Ms. Hilton.
Again, you have to look at this in totality, Your Honor. This starts off with Mr. Copeland saying, why do I have to go through this, man? And Gaither is then going into, I need you to do this. I need you to identify who it is so that I can get started on my investigation. So I can continue my investigation. I can continue my work. So while Mr. Sharp calls it a speech, she's responding to Mr. Copeland saying, why do I have to go through this? And if you look at his body language, he was struggling to move forward and just make the identification. And so she's trying to encourage him to go ahead and make the identification so that she can move forward with her investigation, Your Honor. So again, as the state said earlier, that's in contradiction to what he said here in court. What he said in court, they were forcing him. No, they were talking to him about it. He's responding back to her. I believe in court, he may have said they made him say Tay. That's not true. That's what this shows as well. And so given his in-court testimony, this is contradicting what he said here in court.
All right. Any further argument, Mr. Weinstein? No, Your Honor. All right, Mr. Matthews. Nothing, Cat. Ms. D. Williams. Mr. Harvey. Mr. Steele.
Your Honor, I don't see why this adds anything. I join everyone else, Mr. Sharp's argument. The detective said we're going to pick them off one by one. Every officer is going to be working. The state is saying that Detective Gaither is encouraging Mr. Copeland. That's not needed. That's not the purpose. We don't just play recordings of me speaking with a witness to say I was encouraging the witness. This is just an out-of-court statement offered to bolster the detective, and that's really not appropriate in my opinion, and it's irrelevant under 4012, and then 3 would be waste of time. A lot of this, the state wants to play, these are, I believe, 18 hours of recordings. I mean, at some point, they don't get to just play all these recordings, so I would object.
And I can respond to Mr. Steele specifically, if the court may.
Yeah, I'm in, trying to kind of see why the detective gave it, before it starts, we're trying to stop this, we're pulling every resource in the city. We can't be everywhere, so if I gotta pick these motherfuckers off one by one, waiting on evidence to come back, then I'm gonna do what I gotta do. But you gotta I'm doing what I gotta do. I'm doing it. I'd be inclined to take that out, but the other stuff would be admissible under impeachment by contradiction or relevant.
So which line, Your Honor?
Line 8 on page 181, line 8 through line 12.
That's fine, Your Honor.
It does, I agree with Mr. Steele. It doesn't really add anything to it, and it's for the reasons he mentioned, okay?
Okay, so
right.
line 8 to 12. we can-
Yes. Anybody else have any other comment or any other argument in regards to number 9, 62630, or thereabouts is 62730? All right, I'm gonna, other than that particular admission, omission, or exclusion from, that'd be page 181, using state's transcript, lines 8 through 12. The rest is, can be played.
Thank you.
Okay,
Yes.
all right. And I'll, again, admit an over objection and give a continuing objection. Does the defendant still maintain that none of this is proper and they should not be played? So, okay, all right. Number 10, and number 10 is 63030 through 63150. And you are saying that that's 404A evidence about Mr. Stillwell
Yeah,
and inappropriate comments about character.
yeah, 404A and B.
404A and B. Okay. All right, sir. Oh,
I'm sorry, Ms. Hill.
you want me to, you want to play it first?
Yes, please.
Okay, all right, let's play it. What transcript page is now?
Another portion will be page 185, line 17, through page 186, line 19. And we'll start 630.
630 what?
I guess she wasn't looking at it serious like how it is. I really thought they wasn't. I didn't think they would do it. I didn't think these niggas would try to shoot me. I'm pretty sure I thought really would try to do a kill. They showed me wrong. Well, I know him for shit. He been on Twitter going back and forth with Shannon. Yeah. What the hell? I'm telling Shannon, why the hell you ugly? You can go on Twitter. What's Shannon been up to? Because I know he ain't just gonna sit and let it ride like you getting shot at and all that. I know that. And you know what I told Shannon? Man, let Polly deal with him. No man, he'll play him. You know what Shannon told me that night? The night they shot me in bed. You know that night? I was crying. And you know that night? Man, bro, hell nah, bro. We take anything you can. I'm like, bro, fuck this shit, bro. Let them have it, bro. Let them have it, bro. They kill me, bro. You know what's going on, bro. Jeffery started with Lieutenant Shannon. Police involved with it. They started with it, bro. We ain't going to jail, so we ain't do, bro. You're not going to tell you one of these folks think we did this shit, bro. And that's what I told him. He like, she looked at it. She like, bro, I'm telling you, bro. If they kill you or they hurt you or they, bro, they got to kill them too. Just like him, bro. They don't get your show out of it, bro. We already in the battle phase. We with people we never thought we'd be with, bro. Bro, fuck that shit, bro. Let them have it. That's why I really ain't getting in there. If I didn't, like, I feel like.
And stop at 631. So sorry, stop at 631:50.
All right, Mr. Sharp.
So this testimony or this out-of-court statement by Mr. Copeland about my client has absolutely no relation to any charged conduct in this case. It's propensity evidence. There's no evidence of something that happened that I know of. There's no evidence of something that happened after this date that was supposedly done on behalf of Mr. Copeland in as payback for either the January 28th shooting of Mr. Copeland in the car, or shooting at Mr. Copeland in the car, or the February, I guess it would be 19th shooting of Mr. Copeland, or shooting at Mr. Copeland outside of his house, other than, of course, Mr. Copeland shooting back at those individuals and hitting them in their car. My point being, Mr. Copeland is essentially saying that Shannon has encouraged him to, and said, we need to get payback for them shooting at you. And Mr. Copeland saying, no, I said, let it be, let it be, let it be. This is not testimony about any act that's charged. This is mere propensity evidence that Mr. Stillwell is someone that when something's done to him or one of his friends, he's going to seek retribution from the other side. And again, if the state had overact, and I'm making this up, that happened on March 3rd of 2015, where they allegedly saw the car that was shooting at them on January 28th, then I would say, okay, maybe that has some relevance to this specific act. But there's no act that's charged. And what the state wants, essentially the logical conclusion based on hearing that, is Mr. Stillwell is, a hothead that seeks revenge. That's propensity evidence. That's exactly what's not supposed to come in under 404B. And so I would object. It's improper character evidence. It's improper propensity evidence.
All right, sir.
Yeah, we won't play it.
Okay. I'm gonna use Mr. Adams' favorite saying, easiest decision I'll make today. All right. Anybody else have any other comment about subpart 10, 630, 30 through 631, 50? It's gonna be omitted. Anyone? All right. Okay, we've gotten through the flaggings of Mr. Sharp. Does anybody else have any other time periods they wish for me to discuss with the court? Mr. All right, thank you, Mr. Steele. Mr. Harvey? Ms. D. Williams? Mr. Matthews?
No, you're not.
Mr. Weinstein?
No, Your Honor.
Okay.
When I say no, it's with reference to my continued objection for severance and instructions with regard to all of this evidence. I don't want that to be deemed to be a waiver on the record.
Okay, Mr. Harvey, in no way, I'll note it again for you that you have moved for severance and for 105 instruction, which the court is going to give you continuing objection on, but I'm going to deny that at this time again, okay? All right, sir. Okay. All right, councils, let's talk a little bit about way ahead in scheduling. I believe that you all have, as well as it pertains to Mr. Copeland, June the 10th interview, which is the longest one. It's 9 hours. Is that correct? All right. Have you all been working on, or I'm going to ask the state first and then defense counsels in terms of what you've identified as to what you're going to play and what you wish to omit?
Your Honor, we sent to defense counsel, I believe on Monday, the areas in which the state, I'm sorry, let me understand. The areas in which the state intends to redact. Yesterday evening, Mr. Shard, I think, sent me a portion of the areas that they would like redacted. We haven't had the opportunity to look at those. And then I believe Mr. Adams is supposed to send me the secondary portion of that. And so we'll be looking through that over the course of today and this weekend to determine what, if any, areas we can agree to. Once we finish talking about June, Your Honor, I will briefly just want to get some clarity on February 21st, but after we finish the June discussion.
What do you mean you want clarity on the
So we
21st?
submitted some redactions for February 21st. And I don't know if, kind of along the same lines of the conversation yesterday, if there are areas that the defendants wanted in that the state intended to redact. And if there are those same line of area, we understand the court's ruling from yesterday, but we just wanted clarity because we don't know. And it could be an offline conversation I can have with Mr. Shard to see
I think
what their position is.
I think I can answer this. After speaking with other attorneys involved in the defense of other individuals, I believe that there is an objection to the redactions of the timestamps identified by the state. We understand that the state, in their presentation of the case, they may choose not to present some of these excerpts when they play the tape.
Which tape we're referring to?
February 21st, 2015.
All right.
But I believe that the defense is going to seek to admit portions that the state is not going to seek to admit.
And certainly that, I mean, we can have a similar discussion that we had yesterday, or I can authorize, unless there's been a specific objection, I'm going to say you can play it during cross-examination. Like similar to what I did yesterday.
Yes.
And that's fine, Your Honor. We'll
Okay,
object
yeah.
at the appropriate time.
Yeah, if appropriate, yeah, I'll rule upon it, but I'm, most of the things that, unless there's clear argument to the contrary, will be fair game on cross, okay?
Thank you, Your Honor.
Okay, so let's talk about the June 10th interview. So is it possible for you all to, like, consistent with, this has been very helpful for you all to identify the time periods and for us to work down through them and have discussion one way or another. Are you all in a position to potentially put something together by Monday? And so we can kind of go through the June 10th interview?
The good news is we're all operating off the same transcript for June 10th, and there is a transcript. I believe the transcript's about 550 pages. I made it through 380, and I've identified the specific spots that I object to, and I believe that other attorneys involved in this case adopt my arguments for those first 380. Mr. Adams is diligently working. He's identified the rest, and he is going to send that information over to the state at some point. I don't want to speak for him, but I know he's been working on it. So I think that the state has given us their proposed redactions, correct?
Correct, Your Honor, but I think we're going to be in the same position. So we really need their redactions because I think the state is, we're going to redact what we're going to redact. And if they choose to want to play certain portions, we can object at the appropriate time. So I think we really need to know what their redactions are in order for us to have a meaningful hearing, hopefully on Monday.
So right now they have about 2/3,
Okay.
just by the transcript length, about 2/3 of the redactions, and then Mr. Adams is going to get them the rest.
Mr. Adams, will you be finished by Monday?
Oh, absolutely. They'll have them, I can give them about Saturday.
Okay, all right. Okay.
That works.
All right. So we'll work on, now, as it pertains to, since we'll probably take the most of the day with that, I'm inclined not to call in our juries for Monday.
And Your Honor, I'm going to remind the court that we also have the jail phone calls.
Yes, and there's 11 of those at 2.5 hours. All right, and then you counsel, as you all recall, Tuesday, the 25th, we'll probably just work from about 9:30 to about probably shortly thereafter lunch. So my inclination as well, I don't think we're gonna probably finish with our, it's possible that even if we, that we'll spend or exhaust most of Monday, the 24th and Tuesday, the 25th, getting through the 10th and/or 10th of June, as well as the jail calls. And we may not even be finished with those. So I'm inclined to just tell our jurors, have a nice week. Unless somebody has something to the contrary. Anybody? Okay, I mean, I just don't think we'll be in a position for them to hear anything at that point. All right. Which leads me to July 1, 2, and 3. More than likely, we'll probably use, if we don't finish up our business with the jail calls, we'll probably take that up on Monday, the 1st of July. Tuesday, we'll probably do the in-camera review of Mr. Copeland's ex parte matter. And I will give you all more pinpoint instructions on that particular time and date. But it more than likely will be the 2nd or the 3rd of July. So that's our kind of work schedule at this point in time to clear those issues before we call back our jurors.
So at this time, we're thinking no jury for the week of going to the 4th.
Probably not, is what I'm thinking. And I may tell them that so they can adjust they can govern themselves accordingly. But we have a fair amount of stuff to take care of. So, all right. Anything else, councils, at this point in time? If not, I'll see you all on Monday, the 24th, 8:30 for an anticipated 9 o'clock start time. We'll queue up the 10th, the June 10th, 2015 interview and see where that leads us. Okay? All right, anybody else? Okay, all right. We're in recess until Monday, the 24th at 8:30.